So, dear participants, dear friends, welcome to this 17th Global Digital Encounter. Global Digital Encounter in order to reflect together on the future of the IP world. This initiative, promoted by the Fide Foundation and the Transatlantic IP Academy, is in a moment of reflection between all of us on really key issues for the development for the future of the IP system. We warmly support debate. Therefore, we invite you very much to interact during the second part of this activity, and we really thank our support entities for permitting this pro bono activity with participants from all over the world. We dedicate this 17th encounter to standard essential patents, a subject which is really a hot subject in the future of intellectual property for many, many reasons. First of all, there are many questions on the aspects of essentiality of patents. What is an essential patent? Secondly, we have really key and urgent issues to clarify on the relations between licensors and licensees, in particular on the bargaining power of the various parties and on the resolution of disputes between such parties. This is a key subject. In Europe, the European Commission, since its 2017 recommendations, is moving actively in this topic. In particular, its expert group produced this year already some recommendations on licensing negotiation groups. So we are very, very proud to have with us Elena as one of the speakers, and also speakers from other parts of the world in order to discuss and also comment on these initiatives. We have indeed grouped an exceptional panel of speakers from the entire planet, and we are really, really glad to leave them enlightening our audience, our worldwide audience, on this topic, which is really crucial for the functioning of the IP system in the light of the emergence of new technologies such as IoT, but also other technologies on telecom and so on. So really all our thanks to our panelists and to the loyalty of our audience who is with us now for the 17th time for this activity. Thank you for being with us, and we will continue to connect with all of you, including next year. We will issue a report at the end of this encounter that will summarize the activity that has been done. We have also posted on our website lists of publications. So this is not a webinar among others, but this is a compendium of knowledge that we want to share with all of you. So welcome back to the Fide TIPSA encounters for this hopefully splendid activity. Javier, the floor is yours.
All right. Yeah, thank you, Laurent, and thank you all for coming, and thank you to the speakers and the moderator. In fact, as you said, it's a very interesting and essential issue for the current economy and for the future. Something that was I wouldn't say confined, but very limited in the technologies that would be implied, such as telecoms, has been expanded to others, and we will see this in the future, in the near future. We will see new players coming from other areas of the world. We will see more court of justice trying to have jurisdiction over the problems that have been raised, etc., etc. So this is something that will have an important impact in the economy of data, to which we are working to, or we are now working on. And for that reason, I think it would be very interesting to hear the participants, to hear the panelists, to hear the moderator, and to extract some consequences. Maybe this is an issue that we will need to discuss in other sessions, but for the first time we talk about that, and it's interesting. So on behalf of Fide, thank you very much for coming and for sharing your knowledge with the rest of the people. And as Laurent said, this is not a webinar, this is a community. So we hope that you enjoy, you get advantage for the documents we have shared, and if you have information or documents to share with us, we will be welcome. So Jorge, I think that the floor is yours now.
Thank you very much, and thank you for the opportunity to participate in this panel, and for the opportunity of having, contributed with you and collaborated with you in putting together this excellent group of speakers. I think that definitely we have here the dream team. I've been working in the past a lot with Elena and with Ruud in the context of the expert group of the European Commission. I think that Elena he has a vast knowledge about these issues and in a very holistic way. Ruud is Mr. Patent Pools. I don't think that there is anyone that knows more. I think that the only one that could challenge that would be Jorge. Jorge is I haven't worked with him, but I have attended many of his seminars and participated in panels with him and read all of his papers, and I still read his recent papers. Incredible productivity, and one of the persons that knows more about the issues that we're going to be discussing today. So this is a dream team, and I hope that they enjoy this as much as I do, and that the audience also enjoys this conversation. Now, needless to say that wireless standards, I think, have been an incredible success. I think that we are now empowered with technologies that work well, technologies that have been developing over time, that have been improving over time in a constant way, and that have penetrated the population, not only in the developed world, but also in the developing world and even in the emerging world, to an incredible extent. Having said so, at the same time, and whereas there is no dispute that the collective standardization taking place through standard development organizations has increased the pie significantly and has generated massive value for consumers, it is true that there are very significant disputes about how that pie should be splitted between the main players in their standardization process, namely the innovators and the implementers. They're humans, they're firms, they run companies, they have to manage P&Ls and satisfy shareholders. So, implementers want to pay less, innovators want them to pay more. And that's not surprising. And that has raised a very significant number of issues, battles that, in my opinion, are to some extent battles on the margins, because the overall and most important conclusion of all this is that collaborative standardization has worked well for society than proprietary standardization on government-sponsored standards. The debate has been moving on over time. The European Commission in Europe has been watching very closely that debate, and in particular is trying to make sure that the debate ends in a productive way, because these technologies that in the past were relevant for a number of uses are going to be relevant for an even wider number of uses. And the Internet of Things changes, in a sense, the scale of applications, the scope of applications of wireless technologies, and the impact that those technologies will have for our industrial policies and for economic growth. And not surprisingly, the European Commission has been watching that very closely. And we are going to, in the first instance, ask Elena to tell us about the views of the Commission, to the extent that her restrictions allow her to do so. Before we do that, just to do a little bit of a spoiler, then we will move to a question in which Jorge will be leading the answer, which is, okay, what is happening now with courts in the UK and courts in China claiming that they can rate global rates for these technologies, and what is happening on the litigation front? Is this another thing that we need to worry? Well, how do we deal with that? And finally, we will ask Ruud, but everybody will be invited to comment, including myself, about whether the clear-cut solution for many of the problems that worry us today is to encourage pools and to organize pools more effectively. Okay, without any further ado, Elena, the floor is yours.
Thank you, Jorge. Thank you for your invitation and kind introduction. And thank you, organizers of this event. Well, I'm glad to be here today and to present briefly our initiatives so far and the next steps. I'm also happy to listen to what appears to be an inspiring discussion. As you are aware, in its communication of 2017, the Commission found that licensing and enforcement of SEPs is not seamless. It called for a balanced approach to SEP licensing based on increased transparency. It gave guidance to the industry and announced a set of actions with the aim to improve SEPs licensing. Well, we delivered on those actions. We conducted a number of studies, which you can find on our website. We also published this year the contribution to the debate on SEPs by the expert group, as Jorge mentioned. We also organized a series of webinars covering various aspects of SEPs-related issues. All those actions have shown that while there have been some improvements, important controversies continue to exist. This results in uncertainty at a time the EU companies are facing increasing competition at a global level. Therefore, in its Intellectual Property Action Plan of last November, the Commission announced it will promote further transparency and predictability in SEP licensing, including possible reforms. In line with that, this year, through its Have Your Say portal, the Commission announced that it is looking at a potential reform. So what are the next steps? The first next step is the public consultation, where we would ask you to have your say, to give your input to us. We hope to launch this consultation by the end of this year or early next year, and you have about 12 weeks to provide your answer. The potential reform will complement, take into account, align with the ongoing review of the horizontal cooperation guidelines and any outcome resulting from the question sent to the by the Commission to China under Article 63 of the TRIPS agreement. So why do we care? As the previous speakers have said, the relevance of SEPs in many new industries continue to increase. So we observe an increase in the number of declared SEPs. We observe an increase in the participation in standards development, and a number of new industrial, business and consumer applications using SEPs-based standards are also increasing. A recent example are the wireless batteries. It's just an example. The increasing number of SEPs, as well as the increasing number of SEP holders and implementers of standards, increases the need for a smooth and balanced SEP licensing system. And we need to also take into account that a number of the new implementers are likely to be SMEs. So what is the main problem? I think that there is a large agreement that it is inefficient licensing, which would include hold out, and forum shopping, as we have recently evidenced. In addition, potential implementers, including startups and SMEs, may opt out from using the standards. These problems may affect implementers, for example, by fewer innovative products on the market and delayed investments due to uncertainty on standard compliance. They may also affect SEP holders by decreased incentives to invest in standard-related innovations and in increased cost of financing. Consumers may have to pay higher prices and experience limited competition in the downstream markets. We believe that a balanced approach to SEPs, which would involve looking at SEPs holistically, including all relevant aspects related to transparency, front and enforcement, is the best way to go forward. It aims at creating an environment of trust and incentives for good faith negotiations. As one of our webinar speakers put it, there is tension between the territoriality of patents and the global nature of SEP licensing. We are all aware of that. patent pools and global dispute resolution mechanism have emerged also during our webinars as potential solutions that could deal with that tension. And we agree on that. However, as we all know as well, nothing is as straightforward as it appears. As one member of our expert group put it, in SEPS, the devil is in the detail. We have expressed our support for patent pools within the scope of competition law on multiple occasions. The challenge, however, is to create the appropriate incentives for pool participation and for taking a license from a pool. We have also supported the use of alternative dispute mechanisms. Again, the challenge is how exactly to incentivize the use of those mechanisms. There seem to be some suggestions, yet the question remains as to how could those be implemented in practice. I look forward to the discussion that will follow. It will be particularly interesting to hear whether there are any potential solutions to those challenges. Thank you very much, and I wish us all a fruitful discussion.
Thank you very much, Elena. So let me pick on one of the things that you raised, this tension between the territoriality of patents and global licensing practice. And I'm looking to the other Jorge in the room. I think that this is leading to a number of controversies, and there are different positions in different parts of the world, and we are seeing lots of innovation. I mean, not this time technological innovation, but legal innovation. I must say that I became aware at one point about injunctions. Then I saw that there were these anti-suit injunctions, then the anti-suit injunctions. I don't know whether they are triple anti-suit injunctions, etc. But from your perspective, what is the scope of this problem and how to address it?
Right. Well, Jorge, thank you very much for the question and for the invitation to be part of this really interesting panel today. So the issue arises from this very interesting tension that we've already just mentioned: the national scope of patents versus the global scope of the patent licensing agreements that parties typically enter into. And when parties disagree over the FRAND royalty rate, right, they're committed to charge a FRAND rate by the rules of the standards organization that they're a member of. Parties can disagree whether the offered rate is too high or too low. That's just an economic question. But when they disagree and they can't resolve the dispute by themselves, they often go to court. And so a court looking at this question has two pathways that it can go down. It can view this as an intellectual property infringement type of suit and assess damages for the patents in its country where it has jurisdiction, or it can look at the matter as a more contractual matter and resolve the dispute over what the international licensing agreement will be. And we've had both flavors of that type of adjudication. The first of the global rate adjudications was in 2017 at the UK High Court for Patents in Unwired Planet versus Huawei. But that UK decision opened the door to other countries to believe that they should be able to do this. And essentially any country in which the parties are present and have assets that are at risk of an injunction imposed by the court can impose this global royalty rate, because if the implementer does not accept the rate determined by the court, well, then the court has the power to issue an injunction against its sales in that country. So we're talking about, a dozen countries in which markets in these products are large enough for the courts to exert that type of leverage. And of course, litigation like this has traditionally gone on simultaneously in those dozen jurisdictions or some subset of them. And when courts in countries like the US or China or elsewhere see that the court, for example, in the UK is planning to set a global rate, those courts worry about their ability to resolve the dispute. And this is where we get these anti-suit injunctions. This is where one court tells the parties before it, it can't affect the ruling or the procedure of a court in a foreign country, but it can affect the parties before it. And it can tell the parties before it, okay, you're here in the court in the United States, you are going to be penalized if you try to get this rate adjudicated elsewhere, because it will interfere with the jurisdiction of the US court. And that's the anti-suit injunction. And then, of course, in the other country, parties will try to prevent that from being enforced. And so you have a half a dozen countries between the US, the UK, China, India, France, Germany, the Netherlands, and the list keeps growing, engaged in this duel of the anti-suit procedures. Okay, so this is problematic. As we have just heard, it has caused some diplomatic issues between both the US and China and the EU and China, and is likely to continue to do that. It's also not the most efficient way to resolve these rate disputes. We have a race to the courthouse, and countries are potentially catering to particular types of party interests. And so this is not a logical or efficient way to resolve these disputes. So we can talk about solutions. One solution that I have proposed at various times is getting this out of the court system, having these rates adjudicated on a global basis for the entire standard, for everyone who is involved, both the patent holders and the implementers, through some sort of neutral, non-governmental arbitration tribunal that gathers evidence from all of the parties, both the patent holders and the implementers, to determine the overall rate that should be charged for patents covering a particular standard, and then how to divide it, pool-like, among the holders of those patents in a way that is open, right? Not a private arbitration between two parties, but an open rate-setting procedure that will then give this information to everyone who is involved in the process, and would, I think, relieve some of the international tensions that are only increasing as a result of the system that we have today.
Excellent. Thank you very much. It's a kind of a super pool, or there would be a super pool in a sense, and on the other side, all the implementers together in cutting through all these games that people play these days. Now,
I called it a pseudo pool back in a 2013 paper.
That's correct. That's correct. That's correct. Ruud, I don't know whether you want to comment on what Jorge has just said. Otherwise, I have other questions about pools. You're on mute, Ruud.
Yeah, well, I can quickly comment, and maybe we can come back on that later. The idea of setting up an international tribunal, arbitration tribunal that sets global rates with subholders and implementers for a certain standard, that's appealing, but also there the devil is in the detail. Because to bring the geopolitical issues also into the tribunal, because there will be representatives of the various countries, because otherwise people will not accept the outcome of the tribunal. And that means that you put these discussions that normally go on between various parties and various courts into the tribunal. So there you will have the same type of discussion. So it is just shifting the discussion from one forum to another forum. But the only advantage is that you have one single forum. And hopefully the other people can then come to conclusions, but it will be an extremely difficult process. I would rather, but we can come back to that later, I would rather favor a mechanism where market parties are first given the opportunity to come together and solve the issue, but if they don't solve it, that then the matter is referred to such a type of international tribunal that then decides the rates and the sharing of the pie.
Very good, understood. I don't know, Jorge, whether you want to respond, to react quickly to that.
No, I don't think we disagree. I also think it would be wonderful if the parties would resolve this themselves. And I mean, to be realistic, most standards, this is resolved, right? I mean, these disputes don't happen everywhere. There are most of the cases, is standards in all types of products all around the world where we do have some sort of private agreement. And I think that's the preferable method, of course, but we have seen the parties do not always agree.
Definitely. Now, so let me move to from pseudo pools to actual pools, or to the standard pools, the plain vanilla pools that you have been actually creating in the past, Ruud. I want to ask you about what are the pros and cons of such pooling in the context of the IoT, in the new world in which these technologies that we're all talking about are going to be applicable to a very wide range of industries and verticals.
Yeah, if you look at the current process of doing licensing on bilateral basis, that's in my view not very efficient. You have an implementer that has access to the standard, sees some business opportunity for himself, start to develop products, put them to the market, in the knowledge that someday later on, some set licensors will knock on his door because he's aware that he will need some licensing. And then a SEP licensor needs to negotiate or go after these implementers and negotiate with individual implementers, and go through the same process with each implementer, having discussions about the SEP portfolio, are they truly essential, are they truly valid, are they truly infringed, etc. And then they need to talk about the financials. So in a pool, you make that at least one step more efficient. Because you bring first all the, or a group of SEP licensors together, and that is the requirement from competition authorities, have to have an independent third party check their patents that they put into the pool on essentiality, so that for implementers it is already known that these checks have been verified to be truly essential by an independent authority, independent body. And secondly, because also the licensors put together, they share the cost and they can increase the efficiency of doing licensing. And that means that they have lower transaction costs, and they can share the benefits of those also with the implementers, which means that in all the cases that I have been involved with, in all the tools that I know, the pool rates are a discount on the sum of the individual rates that licensors charge. So that means that the pools can offer attractive rates in comparison with the rates that are offered in bilateral licensing. So that also for implementers, it is far more attractive to deal with the pool because they know that the pool has agreed to these rates, and that they are secured, or better secured, that there is a level playing field among all the licensees, because the margins of negotiations for a pool are relatively small compared with the margins that each individual licensor has in bilateral negotiations. So you bring things more together, which is an assurance for implementers that there will be for them a better level playing field, which is an important consideration for implementers. So there are many benefits, but there are, if you look at the IoT, then there are more players to be licensed for more diverse products in different IoT verticals and different markets. That means that the tools become more attractive for licensing in the IT world, both from the licensor side and from the implementer side. The licensors, they come from a certain sector where they don't have all the knowledge about the markets in the various IoT verticals. They don't know the different practices there. So if they collectively operate, that makes things more easy. And also for the implementers in the various IoT verticals that don't have the experience and the knowledge about SAP licensing in the same way as in other sectors of the industry in ICT, yeah, they benefit from dealing with a patent pool. So patent pools become more attractive in the field of IoT. But we also know that it takes time to create these patent pools, because usually patent pools are created after the standard has been set. And if you want to bring a critical mass of SAP licensors together and have them agree on a program, that may take easily 2 years at least. And that means that that program will become available at the point in time that the market already starts to develop. And what you would like to see is that the pool is there at the point in time that the market starts, so that it can incentivize the growth of the market. So in my view, if we want to stimulate the formation of pools, we need to start already during the standardization process to create awareness for these pools and the advantages that they can bring, so that the participants, the SAP licensors that participate in the standardization activity, can already start to think about, well, does this make sense for us? And if they think about it, the number of companies that they need to license, they can possibly do that on their own. So it is attractive for them to create a pool. But if they start doing that early on, then the pool becomes available much earlier in the process. And once you have one pool for one particular application, one particular product established, and you have these people together, then when the standardized technology will be used in further IoT verticals in the future, these same people that licensors that are already together in one pool can then also create programs in the same setting for these different products in the different verticals. So in my view, yeah, it has certainly benefits to stimulate the formation of pools early on, with the eye on the immense task of licensing SAPs in IoT.
Thank you very much, Ruud. I don't know, Jorge, whether you want to add anything on this. What are your views about the usefulness of pools? And if I may, being a little bit polemical, when you consider that, what about licensing negotiating groups? That is, what about aggregating power on the other side?
I can talk about that, but
I'll bring you back in a second.
Okay, good.
But,
good.
Let me go first to Jorge, and then I invite you to participate on that.
Yeah, so I am very much in favor of voluntary pooling, and of course we have seen some industries, the storage media, CDs, DVDs, were defined by pools, and Philips was very involved in those, of course, and those were great successes. But the parties don't always do this, right? They're all economical, rational actors. Pools were tried in Wi-Fi, and some attempts made in the wireless telecom space, and they just haven't come together in a significant way as they have in some other technologies. And that has to be just a purely financial decision by some of the large patent holders. And I think they're correct that they can maximize their profits if they stay outside of the pool. And obviously there have been studies that show what are the motivations for defecting and holdout behavior, the different type of holdout than but not joining a pool. And generally patent holders who have what they perceive to be the most valuable patents will have at least a financial incentive not to join. And so if there's a way to overcome that would be great. And of course, we've seen that the pools in the IoT space, like Avanci, have been forming with some of the big patent holders in the wireless telecom space, because in those markets, probably lower dollar markets, it makes financial sense. But to break through in the big market today, which is smartphones and mobile devices, possibly automotive, but that's a little unclear where that's going. But at least in the smartphone market, it seems like the parties have had 20 years to come together and make the pools voluntarily, but they haven't. And so my thought is that some additional little push is needed, and this is where the idea of SDO requiring that friend rates that can't be agreed privately get adjudicated in this way is a little push that will help get us there.
Ruud, licensing negotiating groups. You said that you wanted to add something on that.
Yeah, I know that there have been, well, there's not many academic literature on license negotiation groups, but recently the topic has increased attention, has received increased attention, and some articles have been published. And most of what I've seen, that they outright reject the whole idea of license negotiation groups as creating an antitrust risk because license negotiation groups are said to be equal to buying cartels, and that they will also be an incentive for further holdouts because they can simply reject every proposal that a licensor has made and then force the licensor maybe to give up or whatever. So, but you also need to look at it from the perspective from IoT, where you have massive number of companies that need to be licensed. And not all will be big. And of course, there will be groupings that are similarly situated. I'm not talking about license negotiation group where Apple, Google, and Samsung will form a license negotiation group because they are clearly have too much market power. But if there are groupings that understand that they will need to take licenses, but they don't have the experience and they don't have the resources to conduct the license themselves in a way that would optimize the results for them. From a license, for them, it would be interesting if they could collectively negotiate a license, because that is effective for them, because they know that they get a favorable rate, that all their competitors in the same group will be paying the same rate, which will give them the comfort of a more or less level playing field. So then it will lower the cost of having these negotiations done. From a licensor perspective, I think it is also attractive to deal with those because you want, as a licensor, collect revenues for yourself, and you want to get that with at least efforts and as quickly as possible. So you can do that by say, okay, can I also negotiate with a group of companies or at the same time? So once I have reached agreement, then I can quickly sign up all the members of that group, which brings me in and I can move on. Because I have hundreds and hundreds of companies to license. But if you compare it with the smartphone market, there, if you license 5 companies, you have already more than 70% of the market that you have covered. And then you still have, well, maybe altogether 25 companies or so to license. But if you look at all the different companies in the IoT vertical, you're talking about hundreds and hundreds of companies, which means that you need to either you increase your, as a licensor, you increase your resources to do all that, or you give up certain markets, or you have to make sure that you license in a far more effective, efficient way than you have done so far. And addressing certain groups together is an alternative to do the licensing more efficient. Of course, there are always risks with respect to license negotiation groups, antitrust risk, etc., that are described. I agree with that. The risks are there. But instead of saying, well, because of that, we should not look at it, I take the reverse. And given those risks, how can we create a condition that we avoid those risks and create a kind of safe harbor in which these license negotiation groups can operate so that we can make them to work. If I take the comparison, broader comparison with patent law, for decades, they were viewed, well, high antitrust risk because these licensors could come together and force prices on implementers so that they would, in fact, preclude them from entering the market and keep the market from themselves. But also there, through the business review letters and guidelines for the European Commission, we have found a way to make them work, and they are successful. So I say, okay, let's try to create the same guidelines or similar guidelines for a license negotiation group to make them work. There's not been many experience with license negotiation group, but I have negotiated with an industry association, and that took a while, but it was very successful, and we were able to conclude licenses within 6 months, signed up within 6 months with 16 large companies that were major players in a certain product market. So, and we were very happy with that. So there are certainly benefits of license negotiation group.
I find that very, very persuasive, I might say. I don't know whether, Jorge, you wanted to add something?
Just a very quick, I just wanted to put a footnote to Ruud's statement that the writing in this question of collective negotiation has generally raised that this is an antitrust risk that's very great. I would say there is a contrary strain of that literature, which I and others have contributed to, that claims that this antitrust threat is overstated, and that right. It is actually would be quite a pro-competitive step to take, and that the antitrust that regulators could help the situation quite a bit by more explicitly acknowledging the pro-competitive benefits of this. And I'll put the link to the most recent papers on this in the materials for the conference later.
I was not talking about you, George. But other article that I've seen. I know that you are more open to it. Yeah.
I think that we have some questions from the audience. I think at least I have seen a question from Vicente Zafrilla, and I think that I also saw a question from Carlos Muñoz, I believe. So let me ask Vicente whether he can, reveal himself by switching on the video and pose the question to the audience, to the speakers.
Yeah, apparently I can. Okay, thank you very much for this very insightful presentation. I just wanted to ask about two main drawbacks from this system of joint jurisdiction or arbitration court. The first one is how to get licenses inside of it, because in the case of an infringement on the decisions we're seeing, they are binded to the dispute because they are somehow infringing. But to be bound to by arbitration decision, they need to be part of some sort of agreement pool or whatever. So this is something that for some of them might equal to signal all SCP holders that they are actually implementing a standard and they need to get licenses. So this is one aspect. And the other aspect is more political, which is even if we arrive to this consensus of having an arbitration body deciding it's somehow the best solution, still these decisions won't be immune to antitrust or competition law analysis, and eventually we can have a decision from this arbitration tribunal, which is later on challenged or analyzed ex officio by a competition authority, so bringing the fight to another level, with on top can lead to an investment dispute case if it's understood that the decision from the competition authority is actually frustrating some of the expectations of some of the parties. This is the two things I would like the speakers to address. Thank you very much for giving me the floor.
Thank you, Vicente. Jorge, I think that's for you.
I can certainly start. So the procedural question is a good question. How do you get the infringers to pay attention to what happens in this rate-setting tribunal? You don't have to. It's not a court. All that the purpose of this tribunal would be to determine the FRAND rate that is required by the SDO, right? So right now, the FRAND commitment is a commitment made by participants in the standards body to the SDO, and there are third-party beneficiaries perhaps out there. But the question is, what is the rate required by the SDO? The SDO can say, if there's a disagreement, the rate that I require as the SDO is what this tribunal determines. So that's set. Then, if there's an infringer out there who does not take a license, he's just an infringer. You sue him in whatever national court you wish, wherever he's operating, and that court will make a judgment. But what the infringer cannot do is say, well, that patent holder, he owed me a license on FRAND terms and the rate he offered me was not FRAND, because according to the rules of the SDO, it is FRAND, right? So that then a court can do whatever its national rules require. It can just assess patent damages according to whatever damages measures there are. It can put the license in place at the rate determined by the tribunal, but you don't need the agreement of the infringers because the obligation for FRAND is on the SDO participant.
So may just one quickly interject. Can I then say, according, if I understood correctly, Jorge, what you're saying is that if the implementer doesn't accept that that royalty and you know that determination, then could it be then? Are you saying that it should be treated like an unwilling licensee then, or it could be treated like an unwilling licensee in follow-on litigation?
Yes, and you eliminate the whole dispute about whether or not the rate meets FRAND, right? Because that is the most complicated, and all of the experts disagree on what FRAND means.
Yes.
It would be much simpler.
Definitely understood. Sorry for interrupting.
Yeah. So the second piece of the question, this political question, and can the parties go to competition authorities? Can they go to the WTO? Well, of course, you know, creative lawyers will find ways to keep themselves busy. But one thing that I think would be necessary before such a tribunal was put into place is to get some sort of pre-clearance from the major antitrust authorities. So I know the US, this would be a perfect case for a business review letter by the US Department of Justice, which has issued review letters for, you know, from MPEG through the DVD pools through, you know, Avanti. And I think this would be a perfect case for a business review letter. And at least in the US, it's quite rare that there is a successful antitrust action against something that the Department of Justice has issued an affirmative review letter on. I can't speak to what would happen in other countries.
I guess there is work for the European Commission to do with regards to the horizontal guidelines and eventually a block exemption then.
Well, I think that unless Ruud or Elena have anything to add, I think that takes me naturally to the next question. No, sorry, Ruud, go ahead.
The only thing that I would like to add to that, if that tribunal would operate in this way, then even if you disagree and you go to court, the courts will also say, hey, why are you not accepting that rate? Because they will then view you as a kind of unwilling licensee. If the tribunal gets well established and is seen as making the right choices and setting the right FRAND right in between brackets FRAND rates that are generally accepted by the marketplace, it will be respected. And courts will then say, hey, wait a minute, you are wasting my time here.
Definitely, I agree. Carlos, I think that you have a question concerning the horizontal guidelines. That's why I said that there was a natural connection with the last intervention from Vicente. Carlos, would you want to reveal yourself? I don't see Carlos.
Carlos, you are not unmuted. We cannot hear you. You should be able to turn your microphone and camera on.
So while Carlos is unmuting himself and revealing himself, a question that let me go back to this issue of you know, kind of extraterritoriality and disputes between various jurisdictions. So in the absence of the sort of dispute resolution mechanism that Jorge is proposing, would you agree that we run the risk that eventually, you know, and I think that this is a European risk perhaps, that Europe becomes totally irrelevant in this game, because ultimately the courts that will, you know, end up establishing royalties around the world are those of the largest markets. And in particular, you know, I'm not even sure whether the US would be that relevant or it would be China, who in the end, you know, ends up prevailing, given the sheer size of its market, and also other markets which may end up in the Chinese sphere of influence. So I don't know, Jorge, Ruud, how do you see this?
Yeah, we definitely run the risk that this will be a big geopolitical issue with the two main competitors, US and China, having a kind of race or who is dominating party. But also Europe can play a role still there if I look forward to the UPC, for example. Because still Europe is a large market of more than 400 million people, which has a great buying power. So it's still a very attractive market for a lot of manufacturers. You cannot leave it out there. And if, like up till now, ETSI and also the European Commission has taken the lead in setting these type of policies, I definitely see also a role for the Commission here to continue that also in this field.
Yeah, I would agree. I mean, right, the question I think isn't really which is the biggest market, but which courts will act the fastest. And this is the race, right? And this is telling. The market actually provides a wonderful experiment of this with the case at the end of last year, Ericsson versus Samsung, where you have one company who is Swedish in nationality, one company who is Korean in nationality, and the main litigation occurred in Texas and Wuhan, China, right? Because the parties are just picking the jurisdiction that they think will be the best result for them, irrespective of their market. And that can be any court. That could be Germany, right? Germany is a place that has appeared attractive for, in some contexts for this litigation. It's any country where there's a large enough market that an injunction would hurt, would be painful, right, to the other party. I saw one of these cases, Indonesia was even, you know, litigation was initiated in Indonesia for this. And you have the very strange situation in the UK where there was a lot of buzz lately about Apple saying, well, perhaps we will just sacrifice the UK market, which got people quite exercised. I'm not sure that's exactly what happened, but the UK is still a big enough market that it would be painful, maybe not for the largest corporation in the world like Apple, but for most companies.
Thank you, understood. I think that we now have Carlos, and I think that Carlos, now that we can see you, and actually you look pretty young and in good shape. So, you know, floor is yours.
Yeah, thanks a lot, and sorry for the misunderstanding with the setting. So yeah, I mean, I think Elena already shared with me, thanks a lot, a link. However, my question was mainly targeting also the licensing scenario, but from another and potentially new perspective, which is this potential friction, or even I would dare to say more or less articulation between open source licensing and front licensing programs within or in the context of formal standardization settings, such as, for instance, is nowadays happening and is happening already since 5 or 6 years ago within ETSI. So we are seeing this, the ETSI NFV software reference implementation as an example, for instance, or the open source Mano. And these frictions might even lead to a freeze of the development of the standard, because companies are blocking. They have potentially different business models, because at the end of the day, everything is about the rate, everything is about the business model. SEP holders do not want to relinquish their control on their essential assets and even their control within the SDO, I would dare to say. So I think it's a very delicate and interesting context. And I would like to know, first of all, your opinion, of course, and second of all, if it would be pertinent to integrate this kind of new standardization scenario of software-based reference implementations within the horizontal guidelines. Thank you so much.
Thank you, Carlos. Who wants to take this on?
Maybe I can say a couple of words about the study we have done. Carlos, this is a good question, and we have looked into this in a 2019 study, which I posted you on our website. When you go in the studies, you will see the study. It examines the issue in very much detail, and the answer to your question is that currently there is no overlap, because simply front-using standards do not use open source related, standardization. So those in general currently do not occur. And if they would occur in the future, it would depend on the open source license that is being used. But I think that the study looks really into depth of this, and you can adapt it to the situation that you have referred to. I hope that this might be helpful.
Thank you.
Thank you. Thank you so much. Ruud, Jorge, anything to add on this front?
I have participated in that group that look into OSS and FRAN. And yeah, I would refer to the report, because it's an excellent report that describes the whole matter in great detail and with, I think, a very clear way. I don't see it as a conflict, by the way. I think those two can ultimately coexist without biting each other.
Right, and I see that in the chat we have Axel Ferrazzini has added an additional reference to on this front. Okay, I think that we're getting close to the end. I think that we were supposed to be on until 18:05. We're at 18:02. A last word from each of you. Perhaps in reverse order of what we did last time. So we'll start with Ruud very briefly, then Jorge, then very briefly Elena.
Yeah, we looking forward to SEP licensing in IoT verticals. I think that we should create greater transparency with respect to how is the SEP landscape, how is that organized, who are the owners, and what portfolios of SEPs do they have. We also need to solve the issue of what is a reasonable aggregate royalty rate for certain applications, certain product. And we need to organize the licensing. Once we have done that, we need to organize the licensing in a more efficient and effective way through stimulating patent pools and also seeing that we can make licensing negotiations work.
Thank you very much. Jorge.
Yeah, thanks. I mean, I think that one thing that I would say in closing is that as these international disputes, they have increased from being mere disputes between companies to true issues of international relations and politics, with governments more involved than they have been in the past. And as a result of that, I hope that the governmental representatives listening may take at least a slightly more proactive role in eliminating some of the concern that has been raised about some of these private structures from an antitrust and competition law standpoint, acknowledging that these would be pro-competitive as long as they stay within certain guidelines, and that these would be positive steps to take to defuse what is really a brewing trade war between some of the major economies.
Thank you very much, Jorge. Elena, last but not least.
Yes, thank you. It has been an extremely interesting discussion. On our side, I would like to ask you to actively participate in any public consultation we would launch to bring forward your ideas, and do not hesitate to develop those ideas in more detail. For example, I would be also interested to hear a little bit more about Vincente's ideas to why there might be some competition concerns from the tribunal. I'll pass them over to my colleagues in DG Competition. Yes, I'm not such an expert, but we really want to hear from you, and in more detail. Yeah, thank you very much.
Thank you very much, Elena. I think that I share with Jorge that perhaps some of the disputes in the past about between implementers and innovators are now becoming disputes of a geopolitical nature. And I think that that's, we need to, I think that I'm concerned about that. I think that that may lead to escalate, conflict, but also it may lead at one point to the bifurcation of standards. And I think that that would be a terrible mistake for the world. So I know that we have exhausted our time. I can see now that Manuel de Santos has revealed himself, and I then put an end to my moderation. Thank you very much to all the speakers, and Manuel, over to you.
Thank you, Jorge. Can't believe it. 1 hour has passed. Yeah, 1 hour has passed. It has been flying. Yeah. So please understand that for a professor of private international law, this topic is a dream. Yeah. I'm supposed to love anti-suite injunctions, forum shopping, recognition and not recognition of judgments, and so on. So licensing standard essential patents, my dears, is in fact a dream topic. Yeah. A Swedish and a Korean company litigating in the US and in China. Wow. Yeah. But it is not only a dream topic. Today we had the great pleasure to enjoy a great and profound discussion. I find it full of valuable reflections. Just recall the discussion on Jorge's proposal on of an international arbitration tribunal as a possible way out for this mess where we are now. Yeah. So as it has been clearly signaled today, our short, I would say even our mid and our long-term future depends on the way the world of standard essential patents will be organized. And I should say it will be organized in the short-term future, please. Yeah, I believe that it is very difficult to find a topic with so many collateral aspects, with so many complexities, with so many legal innovation. I recall now Jorge Padilla's statement. Yeah. And also with so many aspects where the devil is in the details. Yeah? And here I just recall what Elena and Ruud have told us during the discussion. Yeah? So as it happened in previous encounters, we do have now to review very thoroughly the recording again. We do have to reread the reference offered to all of us. We do have to reflect also on the questions which were not taken on board. Yeah, and we do have to study the report of the encounter. Yeah, by the way, thanks to Vicente and to Carlos for writing the report this time. Yeah. Thanks very much to our speakers. They are Elena, they are Ruud, and they are Jorge Contreras. Yeah. And congratulations to Jorge Padilla this time. You have conducted in a magnificent way this encounter, Jorge. Very proud of you, my dear.
Because these speakers were friends, so I think that made my life easy.
No, but it was very relaxed and it was really very, very high standard. I'm pretty sure you, Jorge, would have loved to have intervened more, but this is the misery of being the moderator, yeah? Anyway,
it's the pleasure of learning.
Yeah, that's it. But anyway, 1 hour has passed so quick, yeah, and so many issues have been brought on the table. So welcome you all to our Encounters family. And above all, also many thanks to all persons who have been connected today. You know, each encounter is a world by itself. By all together, when you take all together, this is a splendid source of knowledge. There are many interested people who follow the encounters on the spot that, believe me, many more people study them later on, watching the recordings of the different encounters, reading the references, reading the reports, reading the questions and the answers. So we are very grateful to all of you. We appreciate whatever advice, criticism or suggestion you could provide to us. Let me close this encounter by thanking very warmly again to all of you and by encouraging to read the report and continue attending the encounters. Our 18th encounter will be duly announced next week and will take place at the beginning of January. So take care. Take care. Come again with us next January. We do count with all of you for our next encounter in January. Thanks for being with us. Merry Christmas to all of you and enjoy the day. Bye-bye. Thank you.
Bye-bye. Thank you.
Bye-bye.